Hello, my name is Tom Patterson, and I started the Patterson Law Firm on April 14th, 2000, to represent businesses, professionals, and entrepreneurs in their business lawsuits. I wanted to make this short video today about small corporations and to discuss remedies when there are problems that develop in small corporations. Everybody knows that small corporations are the backbone of the industry and the economy, and most of the time they have very inspiring stories to tell. Two college roommates decide to start a business, or two longtime friends decide to start a business, or two brothers decide to start a business, or two or more colleagues from one business decide to leave that company and strike out on their own. Most of the time, these stories turn out great. The corporation thrives, people get employed, products are made, services are improved, and everything's happy. However, not always. Sometimes stress develops. In my experience, the stress arises from three things. Number one, the greed factor. If a corporation is successful beyond its hopes and dreams at the start, sometimes one or more shareholders get greedy and they want more of the profits from that business. The second stressor is the opposite problem. The business doesn't do that well and people start pinning the blame. Oh, you're spending too much money on client expenses, you're not counting the paper clips correctly, you're not accounting for our profits, etc. The blame game is common in business, and that is a stress, and it's a stress that happens when the company's not doing very well. The third stressor is when there is a perception that one or the other of the shareholders isn't doing their fair share. So somebody says, well, I'm bringing in all the clients. Or the other guy says, all you're doing is taking clients to the hockey game. I'm the one overseeing the production line. Or I'm accounting for something and you're not doing anything. All you're doing is sitting in the office counting paper clips. There's all kinds of things that people accuse each other of when there is a perception that one person is contributing more to the corporation than the other. Now, here's a story from real life experience. Two brothers started a business. One brother got a patent on a new product. The other brother was great at marketing and had great customer relations. All of a sudden, the corporation got this huge order that was going to make them profitable for years to come. And the greed factor set in. One brother ended up hiring his wife as the bookkeeper. And then he ended up spending money on a sports car. And then he finally threw his brother up against the wall, locked him out of the business, fired him, and threatened him, saying that unless you sell out cheap, you'll never see another dime from this business. Now, what's the fellow to do in that circumstance? Was he helpless? No. The fact is that the Illinois Business Corporation Act and the similar statutes in most other states provide a remedy for a shareholder that is mistreated in that way. So, for example, in Illinois, if one shareholder is oppressing another shareholder, wasting corporate assets, acting illegally or fraudulently, or the corporation can no longer fulfill its business purpose, or the shareholders are deadlocked, the aggrieved shareholders, the one locked out, can file an action in court. And in the circumstance that I just described, that's what we did. We filed an action in court alleging oppression. The shareholder was locked out of his business. We alleged waste because the other person was spending money on sports cars, and we alleged deadlock because they were both 50-50 shareholders in the corporation. So, what happened? We stopped the bleeding of the funds from the corporation. Now, what happens in most of those cases? The shareholder that sued elects to buy out the shareholder that sued him. And then the focus of the lawsuit shifts to what is the value of the business. And typically an expert is required to figure out what the value of that business is. And this is a very specialized field because there are particular rules that experts must follow to value a business, and they are not necessarily the same as they are in tax cases or divorce cases. Business Corporation Act of Illinois, for example, says that the shareholder to be bought out must be bought out for the fair value, not the fair market value. And typically the fair value is calculated without reference to minority discounts or lack of marketability discounts. Furthermore, this is complicated because if one shareholder has been embezzling funds, to take an extreme example, you have to value the company as if those funds are put back into the company. And you can still have an action to recover the embezzled funds on behalf of the corporation. So all those things are very complicated, require expert testimony, and require the knowledge by the lawyers of what the expert standards are supposed to be and how they are supposed to be applied. In brief, then, sometimes you are able to flip the script. And when one shareholder offers to buy your shareholder out, sometimes you can say, I want to buy the other shareholder out. And the court has the power to decide that. The court has extensive powers under the Business Corporation Act to issue remedies. It can decide the price of the buyout, the terms of the buyout, whether there's going to be a non-compete agreement that attaches to the buyout, and they can appoint a receiver. They can appoint all kinds of things to prevent deadlocks. They have almost all the power you can imagine a court might have to implement a correct result. In conclusion, this is just a brief overview of the circumstances for a shareholder dispute, what we call sometimes business divorces. But they are important to know. You are not helpless. There was a writer once who said, a minority shareholder has no rights whatever other than those contained in a shareholder's agreement. And I agree that a shareholder agreement can be important and can modify the rights you have under the statutes. But even without a shareholder's agreement, or even without a good shareholder's agreement, a minority shareholder is not helpless when they are getting oppressed or treated unfairly and in bad faith by the other shareholder or directors or officers. So consult a lawyer that you know or that has experience in this area. If you'd like to ask us questions, our initial consultation is free, and I'd be happy to talk to you about it if you think we could help you. So get in touch with us at the email address provided or the phone number provided, and we'd be happy to provide that initial consultation. Thank you.